Electrician Matthew Moreland was working at an abandoned Jessup, Maryland property that had sustained significant fire damage on December 16, 2025. Mr. Moreland was rebuilding the alarm system as part of his contracted work, and he set off the alarm while testing it. The exchange that transpired after a Howard County Police Department officer arrived was recorded by the officer's body camera.
Police stop.
Hi, how you doing?
Hey, good. How are you?
Good. You're setting off alarms here.
I'm working.
All right. Do you have ID on you?
I do not.
You don't have any ID?
Not on me.
Anywhere here?
Yeah, it's here. What do you need my ID for? I'm working.
I don't know who you are.
Well, I don't know who you are. Listen.
Yeah, you do.
I'm working, my friend.
Okay, look. Step back. Step back. Do you have any ID on you? Or in here? Anywhere?
I think it's in my van now.
Okay. All right. I understand you're working, but
I don't understand what you need my ID for. I'm working.
I have to identify
and I told
you.
him.
I don't know who you are. I don't know who lives here. You're not the owner, or you don't live here, do you? That's why I got to identify you. You're setting the alarms off.
Well, I'm here working.
When Mr. Moreland accuses the police of pushing him, the officer responds that he had only, unquote, backed him up because it was cold outside. But it's evident from the body camera film that the officer pushed Mr. Moreland inside after making contact with his chest and telling him to step back. In the 1980 case of Peyton v. New York, the Supreme Court ruled that the Fourth Amendment establishes a clear boundary at the home's entrance and that, absent extraordinary circumstances, such as when officers are responding to an emergency, are actively pursuing a fleeing felon, or are faced with the imminent destruction of evidence, the threshold to the home may not be reasonably crossed without a warrant. In this instance, the officer entered the house without a warrant and, crucially, without Mr. Moreland's consent by forcibly pushing him out of the doorway. Now, even though the officer claimed that the cold was the reason he entered the house, cold weather typically does not qualify as an emergency that permits cops to enter residences without a warrant. The urgent circumstances theory is the strongest justification for the officer's entry into the house being permissible. However, an activated burglar alarm does not neatly fall into any of the established emergency categories. In the 1984 case of United States v. Dart, the Fourth Circuit Court of Appeals decided that a warrantless entry into a burglarized storage unit was constitutionally permissible where the doors had been visibly forced and officers had reason to believe that the perpetrators were still on the premises. The court's rulings are controlling federal precedent in Maryland. There were no obvious indications of forced entry in this case, and Mr. Moreland, the person who answered the door, was helpful and provided a prompt explanation for his presence. No one was in obvious distress, no suspect was running away, and there was no sign of an ongoing violent incident. In the 1992 case of United States v. Moss, the Fourth Circuit examined a similar context and found that, even in cases where an officer had a reasonable suspicion of a break-in, the circumstances only called for a glance from the doorway, not an entry. The police went much further than that by physically pushing Mr. Moreland back in an attempt to break into the house. Additionally, there is strong evidence that he violated the Fourth Amendment by doing so in the absence of an emergency.
It's not that difficult, dude. Where are you going? Don't walk away from me. Don't walk away. Walk back out here. No, walk back out here. Come on.
Why are you touching me?
Because I don't know who you are. Come on. Let's go. Do you have ID?
I don't. I'm going to call the people that I'm working
Listen, you don't have ID in your truck or anywhere?
I probably do have it in my truck.
Okay, do you understand where I'm coming from? I'm coming to an
going to
alarm.
call the people that I'm working for.
Okay.
All right.
Somebody on the phone doesn't mean that's who owns this place. Jeez. It's not that difficult.
Hey, Paul. So I'm over here and they got the police out here because the alarm's gone off.
Say that again?
I said I'm over here and they've got the police here because the alarm has gone off. Can you get Mr. Coffee to come on over here and clear his situation up? Thank you. And that'd be the owner. He'll come.
Okay, what's so difficult about having an ID?
What are you going to ID me for?
Because I need to know who you are. You're in a house that's not yours, setting the alarm
I'm a
off.
contractor. I'm working for a general company.
Okay, that's great, but I need to make sure you're valid to be here. Do you understand that?
My ID doesn't serve any purpose for that.
Yes, it does.
What does it tell you?
It tells me who you are in case later on you weren't supposed to be here.
So I give you my ID, you're going to...
The police forcibly returns Mr. Moreland to the entryway area after he enters a different room of the house to make a phone call, and he is later told not to leave when he tries to make another call. According to the Fourth Amendment, which only allows an officer to momentarily detain someone for investigation purposes when there is a reasonable articulable suspicion that criminal behavior is underway, these activities most likely constituted a seizure. The officer's admission into the house presents significant constitutional issues of its own, as we covered earlier in this episode, and it is also debatable whether he had the necessary reasonable suspicion to detain Mr. Moreland once inside. On its own, an activated burglar alarm is the type of unclear situation that can lead to reasonable suspicion. However, it does not prove on its own that the person found on the property is the origin of any criminal conduct, especially if that person does not run away, does not act evasively, and offers a plausible explanation for their presence. In this instance, Mr. Moreland answered the door, presented himself as an electrician working under contract, and gave background information that supported his legitimate presence on the premises. In the 2021 case of United States v. Drakeford, the Fourth Circuit Court of Appeals ruled that officers must take into account the entirety of the circumstances when evaluating reasonable suspicion and must not ignore evidence that tend to refute it. Because the police concentrated on the alarm while ignoring the innocent answer that was right in front of him, there is a plausible case that the officer lacked adequate legal justification to hold Mr. Moreland. It should be highlighted, nevertheless, that officers are not required by law to accept an innocent explanation supplied by a suspect. In the 2018 case of District of Columbia v. Westby, the Supreme Court ruled that officers do not have to rule out an innocent explanation before taking action as long as there is a reasonable suspicion of criminal activity based on the entirety of the circumstances, including the plausibility of that explanation. Although the Westby case dealt with probable cause for an arrest rather than the lower reasonable suspicion standard that applies to a Terry stop, its underlying reasoning still holds true in this case, and a court would take into account whether a reasonable officer could have concluded that criminal activity was a meaningful possibility after weighing Mr. Moreland's explanation against everything else that was visible at the scene. This is a data broker's report. Just look at how much personal information it purports to hold, even if it is only a few pages long. These businesses gather our data and sell it without our consent. Furthermore, it is really unsettling that stalkers, spammers, and scammers can purchase the same information. The more I read this article, the more I became aware of how much information on us is out there that most people are unaware of. Aura is today's sponsor because of this. Aura finds the data brokers that are selling your information, instantly removes you from them, and continuously verifies that your information remains off. While there are several services that assist with data removal, none of them are as feature-rich as Aura at the same cost. Aura offers credit monitoring and identity protection in addition to erasing your data. Therefore, you can safeguard much more from a single location rather than using different services for everything. Aura is a US-based firm that focuses on preserving your information rather than making money off of it, which is another reason I appreciate it. Music, Aura does not sell your personal information, and everything is encrypted. Additionally, Aura provides fraud notifications 650 times quicker than rivals. Aura can notify you in less than a second before a criminal has even completed placing a fake order, whilst another service would take 10 minutes to do so. As you watch this video, your data is being sold. I believe it is worthwhile to take the same precautions that I am taking to safeguard my personal data. Aura will immediately remove you after locating the broker who is selling it. Try Aura for free for 14 days by visiting aura.com/audit. Additionally, you can click the link in the description or the pinned remark below, or you can scan the QR code on your screen. Once again, I want to thank Aura for sponsoring this episode.
Are you the only one here?
I am.
All right.
Hey, turn around southbound 108, go southbound. I located an accident.
Do you have warrants or something? Are you scared to identify
not
yourself?
At all. I don't answer questions.
You don't answer questions. Well, guess what? You're going to go in handcuffs in a second.
It's going to be southbound just under the bridge for 108.
Hey, is this Tracy? Hey, Tracy, it's Matthew with Technic Electric. How are you today?
I'm not with the worker here,
I'm
but he's
having a
refusing to
wonderful
identify
time with these
himself.
folks over here. I was just wondering if you guys could come on over here and clear this up for them. They don't, they're worried that I'm not supposed to be here, so. Okay. Well, he said that he's not going to be able to do anything.
I'll talk to him on the phone. Would you like me to talk to him? Who is this?
This is the guy's assistant. Her name is Tracy.
Hi, Tracy. I'm out with this worker who's refusing to identify himself.
Oh, I understand. Not a problem. Mr. Coffey, I have Mr. Coffey in the car. We're on our way to the house.
Okay, how far away are you?
We are just passing Staples on Summer Parkway, so we're approaching Oakville.
Okay, I appreciate it. We wouldn't have this issue if this guy would just identify himself, but he's refusing to.
So Matthew? Oh, okay.
All right, thank you.
It's not a problem. We'll be right there. I thought Mr. Coffey said he let them know yesterday about the restoration that's going on at his home, but we'll be there as quickly as possible.
I appreciate it. Be careful.
Absolutely. Thank you.
Thank you.
Yeah.
Hey, sorry I missed your call. I was on the phone with Tracy. Yeah, I just gave her a call after I got off the phone with you, saying make sure they were on their way over here. Well, look, I've got the cop here, man. He's being redundant, I just want to...
Redundant.
I just want...
I got your worker here who refuses to identify himself.
I don't have a constitutional need to.
A constitutional need to.
All right, Paul. Well, I'll give you a call back once it's cleared up.
You're being audio and visually recorded, by the way.
I get it. I'm going to sit down on that stair there if you don't mind.
Yep, go ahead. I just don't understand why this is so difficult.
It's not going to do anything for you. That's the problem.
You don't know how we operate, okay? And I'm not going to...
Mr. Moreland contends that he is not required by the Constitution to reveal his identity. In the 2004 decision of Hibble v. Point 6 Judicial District Court of Nevada, the Supreme Court ruled that states could ask a person to identify themselves during a legitimate Terry stop, but only if the stop was justified by reasonable suspicion. Maryland does not generally require a detainee to give identification to a law enforcement officer, in contrast to states that have passed stop and identify laws. Furthermore, only those who carry a firearm are covered by the one statutory exception stated in Section 4 to 206 of the Maryland Criminal Law Code. Nonetheless, in certain situations, a charge of impeding and obstructing a law enforcement officer in carrying out his duties may be supported by a refusal to identify. In Maryland, it is a common law misdemeanor to obstruct and hinder an officer's execution of a certain duty by acting or failing to act in a way that does so. Crucially, proof of actual obstruction, rather than just disagreeable behavior, is required for the charge. The Court of Appeals of Maryland overturned an impeding and hindering conviction resulting from a traffic stop in which the defendant gave the investigating officer a false name in the 2011 case of Titus v. State. Due to the state's failure to show how the defendant's actions actually affected the officer's investigation and the fact that providing a false name alone did not meet the actual obstruction requirement, the court determined that the evidence was insufficient to support a conviction. In this case, Mr. Moreland had already disclosed to the officer that he was a contractor doing repairs on the house. The homeowner was present to verify Mr. Moreland's testimony, and the officer did not specify any investigative purpose that identification would serve. In these situations, there is a compelling case that the rejection did not constitute obstruction because it did not significantly affect any recognized duty that the officer was carrying out. Even if a judge found that the officer had the legally requisite reasonable suspicion to request identification, which is far from certain, as we covered earlier in this episode.
Notified the police
He
department.
is now. No, he hasn't notified the police department.
Yeah, they came yesterday.
Okay, yesterday. Today they didn't. And when the alarm company calls to get a code to clear it, they did not answer and did not give the correct code.
Oh, I've got the code.
They didn't call you. They called the owner.
Oh, okay.
This is such a simple thing that I've handled 9,000 times, and you make it difficult.
I'm not trying to be difficult, sir.
But you are being difficult.
Well, I just don't understand what
You don't have to understand.
ID. I mean, I understand that you don't think that I have to understand. But my ID does nothing. It doesn't tell you he's a contractor, he's supposed to be.
It tells me who you are. So later on, if the homeowner comes on and say, hey, somebody was in here, blah, 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 I know who it was.
I've got the homeowner coming, so that way we just don't even have to worry about it.
Well, regardless of that, you asked the question, I'm explaining it to you.
I gotcha.
I won't ask you questions because you don't answer questions.
Other than this, how's your day going?
I don't answer questions.
Lord have mercy.
I'll play your stupid game.
Hey, Jamie, how are you?
How are you?
Good, how are you?
Yeah, Mr. Coffee is here.
All right. Mr. Coffee's the homeowner?
Yes.
Okay, thank you. Appreciate it. You guys got here pretty quick.
Huh?
You guys got here pretty quick.
Yeah, I was on the halfway. Hi, Mr. Matthew.
Hello.
You fixing your lights?
I was working.
Are you listening to a call?
What's that?
Are you listening to a call?
Am I listening to your call?
No, are you?
Oh, that's not mine.
Oh, okay.
You get an ear for when they're talking to you.
Yeah,
It's not mine. I'm sorry.
Just to give you a heads up, I just want to, Mr. Coffee's caregivers, his house was damaged by solar panels,
Oh, wow. Okay.
so they had to basically take the top off the house. He had to move out
Holy cow.
until, so this was all going. So Mr. Matthew was one of the electricians.
Okay.
And Mr. Paul called me. He's the project manager with Strongwall Construction.
Mm-hmm.
So, anyway, Mr. Coffee's going to come in and you can verify everything. Are you guys hearing the alarm and we're not hearing it here?
Was I hearing the alarm?
Yeah.
Yeah, well, I was testing it, and I opened a window, and I came in right away and pushed the code in, and went back to work. So it was wheel for like 10 seconds, and put the code in.
So we got two alarms, one general alarm and then one window alarm.
Yeah, so that means that, and then they're calling the phone, which is, I don't know if it's
He's supposed to call the alarm company and tell them to not report it while I'm working in here.
Yeah.
And that's how you avoid this whole process.
He probably didn't.
I can go down and talk to him.
Okay, if you don't mind, yeah.
No,
Thank you, officer.
You're welcome. Thank you.
Okay, so.
Good afternoon.
Good afternoon. How are you?
I'm fine.
Okay. You're the homeowner here?
Yes.
All right. Do you have identification on you by any chance?
Sure.
That shows this address?
Sure.
Oh, perfect. Thank you.
See, what the problem is, I told another policeman yesterday
Yeah.
that they're working on my house.
Right. You have to tell the alarm company that.
And the electrician in there.
Yeah. Thank you. I appreciate it. The problem is the electrician wouldn't give me any information. He wouldn't give me his name. Wouldn't give me anything. He said it's not his constitutional duty to give me his name. And he doesn't understand that he's setting an alarm off and he doesn't live in this house. Yes, I need to identify who you are. Well, he refused to. So that's why we're here.
Yeah.
Thank you.
Okay, no problem. But the thing about it is this, he got everything hooked up.
Yeah.
But after getting everything hooked up, it came over the board that one of my windows
Yeah.
was open in the basement.
Uh-huh.
He went down in the basement, and none of the windows are open, but one of them was broke.
Oh, okay. All right.
And when that go off, it don't set off the alarm in my house because it's not completely, connected together.
Right, right.
But what I'm going to have him to do, just go in and turn it off.
Well, you can either turn it off, or if it goes off, do you have a cell phone? Do they call you?
Nobody called me.
Okay, yeah, the alarm companies should call you and you can give them like a code.
Right.
And they cancel us, but they said they didn't say anything about calling anybody, so.
Yeah, well, nobody hasn't called me.
Right. Mr. Coffee, are you 91?
Yeah.
Look at your date of birth. My dad was born in 38. He's 87. He lives in Arizona. Still kicking too.
Oh, yeah.
All right.
I'll
Well,
soon be 92. My next birthday's in April.
are you going for 100? Come on, you can do it.
If God willing.
I tell my dad that, hey, you're going to make it to 100. He's like, I hope not.
See, I tell you, it doesn't make any difference with me how long I live. If it's God's will, I go along with it.
I'm with you there. I agree.
Oh, yeah.
When it's your time, it's your time. It's not our decision.
That's right. That's right.
All right. Well, like I said, if you want to talk to your alarm company and have them make sure they call you if it goes off, or set it up with him while he's working for them to call him and he can give a code, then we won't have to come out here if it goes off.
Yeah. Well, as I say, I probably have him to just go on and turn the alarm off.
Gotcha.
If you just turn it off, you see, you won't have to worry about it.
Right.
The officer departed without incident when the homeowner verified that Mr. Moreland was in the house legally. According to Mr. Moreland, Internal Affairs concluded that the officer had not committed any misconduct when he filed a complaint with the Howard County Police Department. He further informed me that he is looking for legal advice and that he has contacted a number of lawyers but has not heard back. For invading a private residence without a warrant or legitimate exigent circumstances, detaining Mr. Moreland on the basis of dubious reasonable suspicion, and reacting to Mr. Moreland's statement of his rights with outrage rather than legal reasoning, the Howard County officer receives an overall F. None of the acknowledged exigencies that would allow a warrantless entry were present here, and the Fourth Amendment draws a clear line at the home's entryway. There was no emergency when the police arrived. Mr. Barland answered the door, provided a prompt justification for his presence, including proof of his uniform, and showed none of the signs that courts have linked to persistent criminal behavior. Nevertheless, without permission or a warrant, the police crossed the threshold and violently shoved Mr. Moreland back from the entryway. No applicable legal standard recognizes his allegation that he entered his residence without a warrant because he was cold. The subsequent confinement is just as troublesome. Before any detention took place, Mr. Moreland had already given a facially plausible explanation for his presence, as was previously discussed, and the officer was required to consider that explanation as part of the whole situation rather than ignore it. The homeowner was already en route to provide direct confirmation, so the officer's claim that getting Mr. Moreland's identity would establish whether he was permitted to be in the house is perplexing because a name by itself would not have confirmed that authorization. Instead of providing a clear legal justification for Mr. Moreland's demands, the officer reacted with annoyance when he patiently tried to exercise his rights. This exchange demonstrates how, in practice, the constitutional protections granted to the home can be compromised when officers cross that line without the proper legal authorization and how, when they do, internal accountability systems do not always offer significant consequences. Mr. Moreland now receives an A for remaining physically cooperative while verbally contesting the officer's actions, calmly and consistently defending his legal rights throughout the interaction, and giving a convincing justification for his presence that the homeowner finally verified. In order to allay any suspicions the police might have had, Mr. Moreland immediately presented himself as an electrician working on the house. Even though the officer's orders were constitutionally dubious, he did not run away, act evasively, or physically oppose them. As was previously said, a detainee in Maryland is not often required to present identification. Additionally, Mr. Moreland frequently and clearly reaffirmed his right not to identify without getting belligerent. This is exactly the kind of balanced, well-informed answer that preserves a constitutional challenge without intensifying an already tense situation. Mr. Moreland protested verbally rather than physically when the police repeatedly moved him. A distinction has substantial legal and practical implications. Even in reaction to a possibly illegal detention, physical resistance can significantly raise the danger of injury and subject a person to further criminal culpability. Mr. Moreland demonstrated good judgment under duress by choosing to continue verbally defending his rights while being physically obedient. I applaud Mr. Moreland for handling a legally challenging and physically forceful situation with the kind of poise and self-control that significantly saved his capacity to contest the officer's actions after the fact. If you would like us to talk about any interactions or legal matters, please let us know in the comments section below.